What's up, everybody? We have some answers for Sarah Boone from the JAC. We have a hearing where she's going to get some answers from the judge coming very soon. This process is moving quickly. The judge doesn't want any delays. He doesn't want to give Sarah Boone an opportunity to delay this trial. He wants there to be justice. He wants it to be fair. And we have an order how and when and where she's going to be able to use this computer. We're going to look at 3 different documents to go through all this today. The most interesting one is the JAC's response to what costs they think will be approved or will not be approved, and will she get standby counsel? The JAC tells us they think she already has her answer. Let's take a look. All right, so the first document we're going to look at is a pretty simple, short document. It's a notice of filing signed by the judge, and it just explains the computer use. So the inmate in this case has been provided with the discovery, with a laptop. They're going to get it to her, and here's how it's supposed to be used. Upon receipt of these items, the following provisions are to be strictly adhered to. The laptop with this number, the charging cable, and the USB devices will be kept in the FDC main control room when not in use. So not in her cell. Not in her drawer. She's not going to have unfettered access to this computer. At no time will the charging cord be placed in the housing unit. Upon the return of the laptop, the FDC main control, the laptop will be placed on the charging cable to ensure it is available for the next day's use. So basically, they're going to charge it, then they're going to give it to her. So what happens one day when it's not charged? What happens one day when the computer loses its charge or doesn't keep its charge for the whole time Sarah Boone wants to use it? You better believe she is going to ask for additional time. She's going to ask for a continuance because she didn't get to use the laptop for a day or two. And some of those claims may be legitimate, but this is the best they can set up as far as process goes for safety reasons to not allow the cord to be in the housing unit. The laptop and the USB device is to be accounted for with the control room inventory. The control room DSTCO will make logbook entries for the issuing and returning of the USB device and laptop. So it'll be interesting if she makes that complaint, yet she doesn't use it all day, every day. My guess is she will, but let's say she skips a day. The judge will be like, you didn't even use it every day. So how can you ask for a continuance for the one day that it died an hour into it or whatever it may be? The dorm officer will make logbook entries for the receiving and returning of these items to the applicable movement officer. A notebook entry will be completed in IMS for every issuance of the laptop and USB device to inmate Boone. The laptop and USB device will be available daily to inmate Boone between 8 o'clock and 4 o'clock p.m., 8 a.m. to 4 p.m. This process will commence once all equipment devices have been received on August 5th, 2024. Remember that August 5th date. Upon receipt of these items, this process will need to be discussed in briefings to minimize any displacement/loss of these evidentiary items. Please contact me should you have any questions. Any changes to the process will be communicated in writing. So that's how and when she can use it, basically every day to 8, from 8 to 4. It'll be charged the night before. She won't be able to charge it. So if it dies, it dies. It reminds me of like Rocky. If he dies, he dies. But she's not going to be happy about that. And if the court orders her to be able to use it from 8 to 4, she's not wrong. So they got to make sure that thing is fully charged. Because I know a lot of non-Mac computers won't just stay working good for 8 hours every time you try to use them. A lot of times you got to plug them in, depending on how old the computer is, things like that. Will we have these problems? Will she complain? Will this be another opportunity to continue the case? We'll see. Will it be another opportunity for her to complain her constitutional rights have been violated? We'll see. All right. The next document. Let's take a look here at the JAC's response to Ms. Boone's multiple motions that she filed. First off, I like that they're doing this. The JAC, or the Justice Administrative Commission's response to motions seeking due process costs, because this is who basically approves or denies or limits or enhances the amount of money Sarah Boone can spend in her defense, or any criminal defendant asking for money for their defense. But what do? The certificate of service that says, I hereby certify that a true and correct copy of the foregoing has been sent by U.S. mail delivery to who? Sarah Boone. Her number, her P.O. box, where it's at, what date did they do this or file this was on 7/30. So this is filed with the court, so she can't say, I was never given this, I didn't get this, unless, of course, she didn't, but we're going to have this paper trail of when they say it happened, and we'll corroborate who was telling the truth, who wasn't, who's right, who's wrong. But I like that this is going to be in before everything that they file. So here's the actual response itself. JAC's response to motion seeking due process costs. Comes now the JAC, by and through undersigned attorney, files this response to the above cited motions as follows. Number one, the defendant is seeking authorization for various due process costs as follows. And this is boiling the 40 pages of Sarah Boone's letter or motions down to a couple bullet points. What does she want? She wants appointment of standby counsel to assist her. She wants costs to take depositions, an unspecified amount for a defense investigator, unspecified expert witness and amount to assist in the defense, and costs of unspecified witnesses to appear at trial. So you're seeing, boiling it all down to it's not very specific. We need to get down to the specifics. How do we do that? When do we do that? We may find out here with the next document we're going to look at. As an initial concern, any future request for due process costs, such as requests for transcripts, investigative costs, experts, needs to be served on JAC prior to the court considering the matter. Meaning you got to tell us what it's for, how much, who the expert is, what their expertise is, why you need them, things like that. The defendant is responsible for providing the JAC with any motions for due process costs that the JAC can respond accordingly to those requests. So what else you'll notice in this document is the JAC kind of instructing and informing and teaching Sarah Boone how the process works. If you want it, here's how you have to ask for it, and then we'll respond, and this is how the process has to go, which I think is good and helpful. The JAC may only pay for due process costs pursuant to section 29.007, 27.40, 27.503, 53042 Florida statute. So it's like wink, wink, Sarah Boone, go look those up. As directed by 27.425 Florida statute and the General Appropriations Act, all due process services are subject to the Florida statutes and JAC contract policies and procedures. The JAC objects to any compensation rate in excess of the established rates. So Sarah Boone, a lot of her answers are going to be here. If you want to hire an expert, ask what their rate is. Go check the JAC. What's their approved rate? If it's not within that approved rate, find another expert. Of course, you can file a motion, argue you need more, fight about it, but that takes time. What you should do is figure out what the rate is, find an expert in that rate, ask us for that rate. That's the cleanest, easiest way to get stuff approved. Standby counsel. What do they think about standby counsel that she's requesting that? As for the appointment of standby counsel, the court entered an order on June 28th, 2024, which we read together, finding the defendant waived her right to court-appointed counsel through her conduct in this matter. Thus, the court has already ruled on this issue of appointed counsel. So as far as the JAC is concerned, the judge has already denied standby counsel. That doesn't mean he can't reconsider. That doesn't mean after Sarah Boone's request, he can't appoint one. And in my opinion, if the court allows or appoints standby counsel to Sarah Boone, no doubt about it, the JAC is going to be fine with paying for it. They would have had to pay for a public defender more hours, more money anyways, to be able to handle this case, or conflict counsel where they bring somebody in like Cashman or whatever it may be. So they'll have no problem paying for standby counsel if the court allows it. Will the court find she's already waived it? Will the court kind of give her one more chance, hedge his bets, maybe prove his point if she also gets rid of standby counsel? But you don't want standby counsel to be used and abused as actual counsel, and then Sarah Boone complained they're not doing enough because she doesn't understand the difference between standby counsel and court-appointed counsel. I think, again, that big date of August 5th, that's when we're going to find out more about this, or what the judge actually thinks about this and whether or not he'll reconsider. Deposition-related costs. As for the cost to take depositions, the defendant is authorized to incur costs to take depositions for those depositions authorized under Florida Rules of Criminal Procedure. The notice of taking depositions substitutes for a court order for purposes of the court reporter seeking compensation for appearance fees. As for service of process, service must be through the sheriff unless the sheriff is unable or unavailable to provide service of process. In those instances where private service of process is necessary, a separate motion to incur costs for a private process server will be required. The sheriff must be used to serve in county law enforcement. So this is them again, in my opinion, saying, sure, these costs, we're going to pay them, but here's the process in which you have to do it. You got to ask for them appropriately. When we approve them, we'll pay them. But yes, we'll pay for deposition-related costs, I believe. As for transcripts, JAC has no objection to regular paid rates. The motion and order for transcripts must reflect sufficient information to identify the proceedings to be transcribed, such as the type and date of hearing date and the type of hearing and recording type and date of recording. The defendant should only order those transcripts necessary for the defense of the case. Now, are they going to quibble about whether something's necessary or not? If a deposition was necessary to take, it's hard to argue it's not necessary to print the transcript and give her the transcript. So we'll see. Maybe they'll give them all just TXT or PDF so she can review them on her computer. The uniform statewide rates are set forth in the General Appropriations Act. Court reporting services cannot exceed these rates. Again, no objection. I don't see any problem with this or the other deposition costs or fees. That's normal. That's, important to aid in your defense. Obviously, I don't see them objecting to that. They'll approve it. Now, if she goes crazy and it's excessive and she wants to depose everybody and order all these rates and get 1 million experts, they'll say no at some point. All right. What about the private investigator costs? AKA the guy that's already showing up that they're already paying, right? So we kind of know what the answer is going to be for that. Pursuant to the uniform state rates, the rates for investigators cannot exceed $50 per hour. As required by Florida law, any private investigator providing services in Florida must have a Class C license from the Department of Agriculture and Consumer Services and be employed by an investigation agency with a Class A license. If the court grants the motion, the order needs to indicate the amount authorized for the defense investigator. Based on the docket, it appears Prison Break Investigations, the guy we met, Billy Lane, may have already been appointed. The JAC does not object to the court authorizing $5,000 for a defense investigator and $500 for the investigator to obtain case-related documents and materials on behalf of the defendant. That doesn't seem so bad. We only have a couple months till trial. $5,000 plus another $500 for case-related documents and materials. That's like saying yes to Sarah Boone. You're going to get this money for that. You've got $5,000 for an investigator, $500 for costs, which you can use by notepads, pens, things like that. Use them appropriately and in a safe way, however the jail allows it. But that's a big yes for her. Yes to depositions. Yes to court materials and investigator. Some wins so far in Sarah Boone's first couple motions. Standby counsel, they think she's already lost, but we'll hear if the judge will reconsider that. How about expert costs? Based on the JAC records, the court previously approved $3,000 at a rate of $200 per hour for a defense mental health expert. The JAC does not object to the court continuing this authorization now that the defendant is representing herself. Boom, another win. Now, it's not a ton of money, but she's got something to work with. Here's the other thing. If these orders have already been reduced to writing, she should have them. But again, she made these motions and was arguing with the court and mad because she didn't have all the case documents at that time. So maybe she has some of these documents now and already knew these answers. But if she didn't, they're all bundled up into one nice document for her. As to the other requests for experts, the defendant will need to file an appropriate motion delineating the following: the identity and type of expert, the amount authorized cap for the expert services, and rates authorized by expert services. So again, this is them instructing her, this is how it works, this is what you need to do. Tell us who the expert is, what their type is, how much you need, and the rates of the services. The defendant has the burden to show the particularized need for each expert witness. The defendant needs to show the services of the experts necessary for the defense of the case. Again, to me, this is them helping her, throwing her a bone, saying, this is what you need to do, this is how you need to do it. Now, she's saying she has not enough time to figure it out, and there are deadlines, and she's trying to stay within the deadlines. As enunciated by the Florida Supreme Court, a party seeking due process costs has the burden to establish the particularized need for the due process services and prejudice arising from the denial of due process. Oh, she'll throw in a lot of reasons why it's prejudice, I'm sure. The determination of whether to appoint an expert is within the broad discretion of the trial court. An indigent defendant must show the trial court that there exists a reasonable probability both that an expert would be of assistance to the defense and the denial of expert witnesses would result in a fundamental unfair trial. So that's going to be something we're going to hear in the future. Mental health, obviously, she's going to need an expert like that. But if she asks the court for 5 experts, he'll probably limit her to how many. I don't know. It'll depend on the arguments, the type, the reasons that she needs these experts, the cost of them. She's not going to have unfettered access to experts as a private person would with their own funding. But maybe she'll get more than one mental health counselor. But why does she need them? Who does she need? How much do they cost? She has the burden to prove all that, provide all that to the judge. Costs ordinary witnesses. The defendant will need to submit a more detailed motion delineating the witnesses she seeks to summon for trial and the anticipated costs associated with those witnesses. Fair. They're not going to say no as long as it's reasonable, as long as it's necessary in her defense. Requirement for JAC due process contract. If any providers desire direct payment, the JAC's procedures require that the vendor to execute the appropriate contract and follow the JAC's billing and audit procedures to obtain payment. Because of the unusual circumstances presented in this matter, JAC requests to participate in the hearing set on August 5th. There's that date again. JAC requests to appear through communications equipment and can be reached toll-free at this number. Wherefore, the JAC requests, should the court grant the defendant's motion, also include in its order the specific due process services authorized, as well as hourly or per unit rates and maximum fees authorized, and that the provider be paid in accordance with rates, terms, and conditions set forth by the Florida statutes and the JAC contract policies and procedures. So some people that sent me this thought the judge did this and signed this. It wasn't. It's the general counsel working for the JAC, which is the Justice Administrative Commissions. They hold the purse and the purse strings for defendants in Sarah Boone's situation, and indigent defendants, public defenders, things like that. So this was a very kind motion, a gracious motion, a helpful motion, an instructive motion. Sarah Boone won certain things. They're going to give her money for certain things. They've already kind of decided this, but they're letting her know again. They've told her what she needs to do, asking for future money, and how she needs to be more specific in some of the things she's already asked for. So I consider this a good thing, a helpful thing, something that's going to promote justice and encourage justice being furthered in this case. But one of the things they asked for is they want to be present August 5th. So what is going to happen August 5th? You may ask, we will answer. There's going to be a hearing. Our first hearing where Sarah Boone has filed motions, has won some motions, is asking for the judge for some things. The judge is going to have to rule. She's going to have to respond to the judge's ruling. The state may argue against it. They may say nothing. They may be in favor or be in agreement with her. We'll see. But this will be the first motion August 5th. I assume you guys are going to want to hear a breakdown of it. If you do, let me know in the comments. I don't want to make assumptions. We all know what can happen when people make assumptions. But hit the like button. I don't think I've said that yet. Maybe I did, maybe I didn't. But hit the like button on this video too, please. All right. Order setting hearing. This matter came before the court, and the court, after reviewing the file and being otherwise informed on the premises, it is hereby ordered and adjudged as follows. By the way, Sarah Boone handwrote these motions. They got in there, near the end of July. Immediately, the JAC responds. Immediately, the judge sets a hearing on August 5th. I'll tell you right now, I don't get that kind of turnaround. Unless it's really close to trial, like within a month, we don't get this kind of turnaround. They are trying to be helpful to Sarah Boone, a pro se defendant. They know how hard this is. They don't want to make it harder. A hearing is scheduled on August 5th, 2024 at 8:45 in courtroom 12A. And we're going to be dealing with the following. Number one, scheduling a deadline regarding production of state's exhibits and defendant's exhibits. Number two, scheduling a conference for defendant to view all the state's exhibits in courtroom 12A. So that's how she's going to be able to view their exhibits. They're going to bring her to the courtroom, lay them all out, let her take a look at them, probably take as much time as she needs with them. I would say she can even take multiple days with them. She should be given photocopies or at least a flash drive where she can review the state's exhibits on her laptop from 8 to 4. Scheduling a conference for the state to view all defendants' exhibits in courtroom 12A. So what they usually do for defendants is they can mark kind of page numbers, bait stamp numbers. They don't do it perfectly, but if they have pictures and they just kind of lay them all out, the state, the court, somebody will help her kind of put them in order. Here's 1 to 20, whatever it may be. Schedule a deadline for receiving state's objections for defendants' exhibits. Schedule a deadline for, did it say defendants? Oh yeah, okay. For state's witness list, defendant's witness list. Deadline for receiving defendant's objections to the state's witness list. Did it say objections of the state? Oh yeah. Defendant's objections to state exhibits. Okay. So she'll be able to make her objections, obviously, like anybody else. I object to 1, 6, and 9. She's probably not going to give her reasons. The judge will have a hearing. She'll argue why. The judge will make a call whether they're in or out. Schedule a deadline for receiving the state's objection to the defendant's witness lists. By the way, a lot of these things, right? The timing, when you can get this stuff in, it may be altered because it seemed like Sarah Boone was worried about some of the timing. She felt like the deadlines were too short. There is no way in heck the judge is not going to extend some of these deadlines or be like, whoop, you missed your time and you didn't even have the discovery, but you didn't tell us what witnesses you wanted to depose. So while Sarah Boone did the prudent thing to say, I need money. I want to depose witnesses. I want experts. I feel like the deadline's coming up. I don't want to miss the deadline. Here's my motion, even though it's vague. Protecting the record. Kudos. But the judge is not going to strike her on something like that or strike any witnesses. What else are we going to do at this hearing? Well, we're going to hear the defendant's first motion to acquire an investigator. We're going to hear defendant's second motion to acquire costs for an expert. We're going to hear the defendant's third motion to acquire all witnesses, costs to acquire all witnesses. We're going to hear the defendant's fourth motion saying she wants depositions to be taken. And lastly, I think it was the first thing she asked for. It was the first thing the JAC responded to, but it's the last thing in the judge's order setting this hearing of what we're going to talk about. I think it's because he may wait till the end. We'll see. Is the motion requesting immediate relief to the defendant by appointing effective standby counsel to aid and support and in preparation of her criminal case for the trial. Again, she filed all this July 18th. JAC responded by July 30th. By July 30th, the judge also set this hearing date for August 5th. That is as quick turnaround as you can possibly get in the justice system. And all of this was signed by the judge. And here's the certificate of service. So how about that? We're going to get all these answers August 5th. I hope he rules. I think he will. Reserving ruling just wastes time, in my opinion. You should kind of know what you're going to do. Hear the arguments, make the call. Will she get standby counsel? That'll be interesting. I think she'll get all the costs she needs to do the reasonable and necessary things to defend herself. She's going to be filing a lot of motions. I think she's going to have a lot of objections. I can't wait to hear when they look at each other's witnesses and exhibit list. This is going to be a very interesting trial. A pro se defendant that is not going to look and sound like Darrell Brooks, I don't think. Maybe more like Ted Bundy. And I'm not trying to compare Sarah Boone to Ted Bundy that way, but more competent seeming and sounding. But we'll see. What do you guys think? How do you think it's going to go? Were you surprised that JAC is going to authorize some of these payments? I want to know what questions you have. Hit that like button, subscribe to our page, and we're going to keep following this case. But for this video, it's all we got. Till next time, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.